So that is from Mr. Lempa and Mr. Kamau.
Mr. Kamau, you want to say something?
Please, Your Ladyship, when we came for the first time to court, I think there was a lot of ice which has melted. We've been literally working around the clock. Your Lordship, we absolutely recognize, and I feel with the court that the priority we have is to purge the contempt, and we have been working around the clock to provide a situation where the contempt is purged, and we shall be able to do a return to work formula. Your Lordship, we have a draft of the recognition CBA. We have been consulting very, very widely and really working very, very hard. So we pray that the court graciously extends the time just so that we can have the very little time that we need to now clinch the deal. And the Commission is extremely committed to this process.
Lady, for the union, I would like to echo the same sentiments. My lady, having personally been present in those meetings, I would like to report that indeed, as has been stated by both councils, we have made tremendous progress in resolving the impasse. My lady, as has been indicated again, it is indeed true that the draft recognition agreements for all 47 counties have been forwarded to the claimant Council of Governors. Further than that, my lady, we have managed to go through the entire body of the CBA, apart from a few clauses, and we are in agreement with the employer on the clauses. My lady would, however, wish to report that the time has been used as diligently as possible, save for the fact that the meetings were convened from Thursday. So we have to recognize that we lost a few more days earlier, but as of Thursday, we have been indeed working around the clock to try and resolve the impasse. My lady, my request, my very humble request, will be that if the court is amenable to graciously grant us a few more days, I would request for 7 days. We can come back next week on a day like this. I believe by then may not be necessary even to report anything, but we would have possibly managed to resolve the industrial action. So my lady, it's just a request for more time as we finalize on small issues that have been left.
Let's hear from the other side.
My lady, there are two issues before the court. The court proceedings and the mediation process, my lady. I wish the court could give us a ruling, the ruling which is pending before this court. Because, my lady, you are not being told how parties are making efforts to purge the contempt. There is contempt in this court, and there was a ruling to review the orders, my lady. I wish we could get the ruling on that. Then if parties have to continue with the mediation, my lady, we do not have an opposition to that. We can proceed with those mediations outside the court. But my lady, the proceedings before this court have not been settled.
Yes, Eunice.
My lady, I think it's in order for a court to give suspended sentences. That is a common practice. However, when a court gives suspended sentences, it's often given on condition. And this court has been very clear on the conditions given. That let's suspend it for 3 days on condition that ABCD should be done. And it's been done now over and over and over and over again. When the conditions are not met, therefore, and you have two situations that you're dealing with. One is a sentence which has actually been, it's actually been given, and so this process is done. And then there is the other process which is going on, which is negotiations, and we really appreciate the tight position within which this court finds itself. But in terms of the negotiations, we've even had Council Washika talk about CBA. There's nothing to do with CBA so far where my client is concerned. Although I'm informed that in terms of recognition agreements, there's progress, which we appreciate at this point. But we have to face the fact that we came to this court to stop and avert a strike action. Okay? You have not been given the opportunity even to interrogate the CBA to know what it is all about, the recognition agreements. So let us deal with the issue of contempt and not treat certain sections of this Kenyan society as more special, as more deserving than the rest. If my neighbor steals my ducks from my compound, I'm sure we will proceed with the process. And the Kenyans like any other. So in my view, I think the court also ought to pronounce itself on the issue of the sentence, one way or the other. We are not opposed to the issue of continuing negotiations, and as you can see, there is no indication as to what time. You asked counsel from the Kenya National Commission on Human Rights to give us an indication of time. They just talk of time, give us time, Nobody has more time. Nobody has more time to give anyone, particularly where we see that there has been no demonstration as to what more time is likely to give. So let's proceed with the issue of contempt. And I think both parties are both anxious and eager to hear the ruling and to move on. So even in terms of more time, if you're minded to give it, I think it's your discretion. We all know even what the Bible says about discretion, my lady. I think on this one, I don't want to quote what it says, but it says, discretion will preserve you. Okay, but I think that's all I wish to say. It's in your hands. You probably need to give directions, but to separate the two issues very clearly.
Maybe we could respond to what has been said.
I'm already writing a ruling.
A ruling?
Yeah, after hearing both of you.
I thought it would be some...
On my way forward.
Some statements have been made that we have not been...
Okay.
Yes. My lord, my lady, we have indicated very clearly that our return to work formula that has great details on how to purge the contempt is already underway. And we have actually asked for 7 days. We have not just given general statements. We have asked for definite time. Your Ladyship, it is not in the interest of this court or any party in this court to take an action that is likely to jeopardize the negotiations that have been said to have taken great strides. A lot of progress has been made, and therefore putting a doctor behind bars, my lady, is likely to aggravate the negotiations, mediation that has really advanced. Putting a doctor behind bars, my lady, is the doctor will be suffering personal pain without addressing the issues that is likely to find a long-lasting solution to this problem. We put them behind bars, negotiation collapse. What does that help us, the general populace there, continue to suffer the violation of the right to medication, which is a continuous violation? So that we are pleading and we are saying a lot of progress has been made, and this court.
I wish you could be saying the progress made is this. These are the documents.
Yes, we
this
have.
Is what we talk. This is where we sign.
Yes,
Then
we have been
progress.
chairing this mediation together with Court Secretary General, who is not here. And these are the instructions from the chairperson of the Kenya National Commission on Human Rights. And I have with me here Victor Kamau, who has echoed the same sentiments. Within a few days, we'll be in a position to have purged the content, which will be in a position to present a very detailed return to work formula, which will be a double-edged sword, punching the content and providing a lasting formula to the problems, my lady, so that it is not in the interest of any party, and especially this court, to do some things that are likely to aggravate the situation as it is, so that we are pleading for more time. 7 days is not a long time, so that by next week we bring a return to work formula, we sign them before this court, and then patients across the country start receiving medical attention, my lady. So that we plead with you, give us more time, suspend, you have been patient with us, suspend the ruling for 7 more days, so that we solve these problems once and for all, my lady. Unless you have a question that you want me to clarify, that's all for now. Victor Kamau would like to say something.
Through your leadership, we do again completely understand and identify with the court's frustration. But your lordship, I'd like to assure the court that we are focused on purging this contempt. And we have gained ground. We have actually broken a lot of ice. I think that by last time we came, we were not able to say that there was even a tunnel through which a light could be seen. But now we can very definitely say there is a light at the end of the tunnel. And your lordship, your gracious discretion will be the thing that really clinches the deal. We are not expecting to come back with you to you saying that we have not resolved the problem. So on that understanding, your lordship, we plead and ask that you temper the court's justice with a little more discretion and time, so that we can do what we need to do. We are very, very engaged. Right up to this morning at about 1 a.m. we were in the office really talking, and we believe that it will bear fruit in very, very little time. So your lordship, we again beseech the court to give us final discretion.
So as you said, Commissioner Kamau, you must have been writing down some documents. That's what I'm saying. Can I see? Can I have evidence of the progress we are talking about? We're just talking. You know, in court, everything you say has to be documented. And I must see proof of what you are saying is progress.
With your kind permission, I think we have exercised a lot. I'm just...
I want them to conclude so that I make my...
It was just a point of order, my lady. Because, if you allow me, just a point of order. Even as we indulge Mr. Kamau, I think we are before an honorable court. They were here a week ago saying they are filing some documents before this court. We haven't been served. We do not know what interest they are serving as interested parties. We do not even know them properly. So I don't even understand how the process is going, and yet we are indulging them because we all want this issue to be resolved. But who are they? Where is the report of the 1 week? My lady, I do not, I leave it there.
My lady, with your kind permission. My lady, with your kind permission, in terms of actual deliverables that have been met so far, my lady, indeed, the process of mediation required us to sign confidentiality and non-disclosure agreements. Yes, my lady, I'm just explaining the process. My lady, all these documents were held by the National Human Rights Commission. My lady, we indeed, as I have confirmed, we have indeed forwarded recognition agreements through the COG to all these county governments, my lady, and they are aware of that. Even the employer, the Ministry of Health, in those meetings, as late as yesterday night, as indicated by council, at 1 a.m., my lady, we were still polishing up on those collective bargaining agreements, my lady. And we indeed, personally, I appended my signature to that draft that was prepared. But all these documents will be able to be produced in court, even as soon as tomorrow, my lady, if possible. But we are saying that they are deliverables.
Mr. Ashika, they are deliverables. The court must see them. That is the only way this court will be convinced that there is progress being made, but you can't keep talking air for me.
My lady, through the court. For example, what you're saying is that personally, my clients may not have these documents with them. If I had them, I would have produced. But these are documents in the possession of the Human Rights Commission. My lady, this what is before you is the recognition agreement that has been forwarded to all these counties. So in terms of deliverables, my lady, we indeed are working tirelessly around the clock to produce them. I just cannot produce them now, but if you give us time, we'll be able to produce them. But we have appended the signatures on final drafts of documents that are ready to be signed.
Okay, I've heard you. Can I have the containers in the dock? Keep it. I'm not saying it should be produced. On the 12th of this January, on 12th of January this year, this court sentenced the union officials to 1 month suspended sentence. It is exactly 1 month since I gave that sentence, 1 month, on 12th of January, today being 13th of February, so it's exactly a month ago. I gave that suspended sentence on certain conditions. Those conditions have not been met to date. I agree that I also gave an intervention to be brought in, the mediation process, which is welcome and we should proceed and continue. However, this contempt has not been purged to date as we speak. I'll therefore proceed today. I'll deliver my ruling. The interventions on mediation may proceed from now on. This is my ruling. This is the background to this matter. The matter came before this court on 1st of December 2016, was placed before my learned brother Justice Aboda, where the claimant sought the following orders. 1. That the Honorable Court be pleased to certify the application as extremely urgent and that it be heard ex parte at the first instance on priority basis. 2. Pending hearing and determination inter partes of this application, an order be issued restraining the defendant / the respondent by themselves, their members, agents, employees, or proxies from calling, convening, proceeding with, or engaging in a strike or withdrawal of labor as per the notice dated 14th November, or from engaging in any related adverse actions. 3. That pending the hearing and determination inter partes of the main suit herein, an order be issued restraining the defendant / the respondent by themselves, their members, agents, employees, or proxies from calling or engaging in any assemblies, gatherings, mass rallies, or any related adverse actions in furtherance of the notice by the respondent dated 14th of November 2016. 4. The Honorable Court do issue a declaration that the notice dated 14th November 2016 calling for a strike by the respondent and its members upon the lapse of the said notice is unlawful, and that any resultant strike or an unprotected strike. 5. That the Honorable Court be pleased to direct that the dispute be subjected to an inclusive process of negotiations to resolve any outstanding issues arising from the collective bargaining agreement dated 27th of June 2013 in such a manner and within such timelines as this court will direct. 6. Pending the hearing and determination of the claim, an order be issued restraining the respondent by themselves, their members, agents, employees, or proxies from calling or engaging in any unlawful assemblies, gatherings, mass rallies, or unrelated adverse actions. 7. This Honorable Court be pleased to grant other orders as it deems just and expedient. 8. Any further relief that the Honorable Court may deem just to grant. 9. Cause to be provided. The application was premised on the following grounds. 1. That the Constitution of Kenya 2010 introduced a new system of governance in Kenya through devolution of power to 47 county governments, each headed by a governor, with its own legislative assembly alongside the national government and its own public service board. 2. That Article 186 and the fourth schedule of the Constitution sets out the functions of the respective levels of government and places county health services within the mandate of the county governments. 3. That to coordinate the functions of the counties and converge on issues of common interest, the Intergovernmental Relations Act No. 2 of 2012 established a council that brings together the 47 governors and that is known as the Council of Governors, the plaintiff, the applicant herein. 4. That the defendant, the respondent, represents members who before the coming into force and implementation of the 2010 Constitution were employees of the Public Service Commission. 5. That after the 28th of March 2016, when the county governments officially commenced operations with the swearing in of governors, members of the defendant / applicants ceased being members of the employees of the Public Service Commission and became employees of the county government, reporting to the County Public Service Board of each county government. 6. That on the 14th of November 2016, the defendant, the respondent, issued a 21-day strike notice addressed to the head of public service. 7. That the respondent have further threatened to proceed with the strike and paralyze the public health system and to ground emergency services at public health facilities across the country. 8. That the strike notice is within the respect to a collective bargaining agreement entered into on the 27th of June 2013 between the Ministry of Health and the respondent. 9. That the dispute, the Council of Governors and the county governments having been in place by June 27th, 2013, they were never involved nor informed of the negotiations towards a collective bargaining agreement eventually executed on 27th of June 2013, and yet the same was with respect to employees of counties. 10. That the dispute express constitutional provisions relating to the mandate of the Salaries and Remuneration Commission, the defendant, the respondent, together with the Ministry of Health, hastily executed the collective bargaining agreement on 27th of June 2013 with no regard to the Constitution and the mandate of the Salaries and Remuneration Commission. 11. Further, and in addition to the above, the Court of Appeal in Kenya has since reaffirmed the centrality of the SRC in the determination of the remuneration and benefits of all public servants in a decision that is unchallenged to date. 12. The plaintiff, the applicant, wishes to bring to this Honorable Court's attention the fact that following a stakeholders meeting held on the 27th of November 2016 at Laiko Hotel, regarding the collective bargaining agreement dated 27th June 2013, it was agreed among others as follows. 1. That the already signed collective bargaining agreement was incapable of being registered in its current form without reviewing it to ensure inclusivity. 2. That the collective bargaining agreement ought to recognize changes occasioned by the devolved government structure and the necessity of incorporating the county governments as an employee of doctors at the county level. 3. That the respondent engage the claimant herein with a view of having recognition agreements between the respondent and the county governments. 4. That the respondent incorporates county governments in the collective bargaining agreements as an employer. 5. That key factors in the collective bargaining agreements be delineated in terms of legal, policy, and administrative, and that the various actors address their specific mandates with respect thereto. 6. That the collective bargaining agreements be fully alienated to be aligned to the existing laws and regulations to ensure that it does not contravene the Constitution and prevailing laws, including the Salaries and Remuneration Commission regulations. 13. That the plaintiff applicant states that the respondent ought to have taken leadership with respect to adherence to the resolution passed during the said meeting, but has failed to take any substantive steps to ensure adherence thereto. 14. That the said collective bargaining agreement could not be adopted by the Industrial Code due to outstanding contentious issues, including the participation and inclusivity of all interested parties under the 2010 Constitution, including the plaintiff applicant, and this is the position pronounced by the Honorable Court in October 2016. 15. The defendant respondent is frustrated by the failure to and inability to adopt and implement the collective bargaining agreement of 27th June 2016. 16. That the plaintiff respondent is a major stakeholder to the terms of the provisions of the collective bargaining agreement dated 27 June 2013 on behalf of its members who are mandated to manage county health services. 17. The members of the defendant, the respondent, are paid their salaries and remuneration by each respective county government, which is responsible for the budgeting and financing of the county. 18. That a decision to increase wages is dependent on the budgetary projections, plans, and allocations to county governments. The budgeted circle is stipulated by law. That the defendant respondent has not exhausted all available mechanisms for negotiations and for collective bargaining as is provided by law. 20. That the threatened strike action is illegal and a contravention of the Labor Relations Act, which prohibits strikes or lockouts of employees engaged in an essential service, which essential service is described in Section 81 as one where, if interrupted, will endanger the lives of our people. 21. That the right to strike is limited by law, and in the totality of facts and the law in this case, this right does not arise. 22. That the threatened strike, if not stopped, is likely to lead to massive loss of lives, which lives cannot be adequately compensated by an award of damages. 23. That the balance of convenience is in favor of the plaintiff applicant's case. The following orders were granted by Justice Aboda upon hearing the applicants. 1. That the same be and is hereby certified as urgent. 2. That the strike notice issued on 14th November 2016 be and is hereby suspended for 30 days. 3. That this Honorable Court hereby directs that the dispute be subjected to inclusive process of negotiations to resolve any outstanding issues arising from the collective bargaining agreement dated 27 June 2013 in such manner and within such timelines as the Honorable Court will direct. This order was served upon the respondents, the Kenya Medical Practitioners, Pharmacists, and Dentists Union as by the Court's directive to serve them through substituted service on 7th of December 2016. The respondents' officials named in the application were also issued a summons to attend court on 13th of December 2016 at 9 a.m. In answer to the court summons, the first respondents' officials attended court on 13th of December 2016 in the presence of their counsel. Directions were given in regard to the filing of pleading and consolidation of this cause with cause number 247 of 2016. The import of the court order of 1st of December 2016 was also explained to the respondents and these officials present in court. The court categorically implored the respondents and these officials to cease strike action immediately and give dialogue a chance as directed by the court on 1st of December 2016. This cause was now listed for 19th of December 2016. On 19th of December 2016, when the case came up for mention for further directions, the first respondent officials were absent in court, but their counsel was present. He informed court that the strike action had not ceased as directed, but they had filed a preliminary objection which they wished to argue. Counsel also informed court that they could not have obeyed the court order because the strike had already commenced. The court found the first respondent and these officials were guilty of contempt of court orders of 1st of December 2016. Warrants of arrest were issued against the contemners which were to be enforced by the OCS Kilimani police station. The matter was subsequently slated for mention for further directions on 12th of January 2017, on which date they were sentenced to 1 month suspended sentence effective 26th of January 2017. The respondent then proceeded to file another application dated 9th January 2017, wherein they sought the following orders. 1. That the matter be certified urgent and be heard ex parte on the first instance. 2. That execution of the court order of 20th December be stayed pending hearing and determination of the instant application. 3. That there be a stay of the ruling and orders of 20th December 2016, directing the applicants to appear for sentencing for contempt of court orders pending hearing of the respondent's application filed in the Court of Appeal on 28th of December 2016. 4. That the Honorable Court directs that the cause of the application do abide in the appeal. The application was premised on the following grounds. 1. The applicants intend to appeal against the entire ruling and orders of the Honorable Lady Justice Helen Wasilwa delivered on 20th of December 2016 and have already filed a notice of appeal dated 21st December 2016 in accordance with Rule 71 of the Court of Appeal Rules 2010. 2. That the applicants have already requested for certified copies of the orders and proceedings for purposes of lodging their record of appeal. 3. That the applicants have an arguable appeal with high chances of success, which raises issues of significant importance on the relationship between the applicants and the respondents as relates to the devolved system of government. 4. That the applicants on 16th of December 2016 raised a preliminary objection to the jurisdiction of the Honorable Court in hearing and determining the cause number 2486 of 2016. But the Honorable Court, Lady Justice Helen Wasilwa, proceeded to hear the matter without taking the consideration of the preliminary objection and found the applicants in contempt of court order of 1st December 2016. Number 5, if interim stay is not granted, the applicants shall be sentenced, and there is real and pertinent danger that unless this court stays the orders of 20th December 2016, the applicants shall be sentenced and are likely to be committed to civil jail, and arrest warrants are going to be executed and to the extreme detriment of the applicants. 6. If the sentence ensues and the execution of the said order is allowed to proceed and the appeal is eventually heard and allowed, the applicants stand to suffer irreparable damage of having their liberty curtailed up to until this application is heard and determined. 7. If sentencing proceeds, the Honorable Court may issue warrants of arrest, and the applicant's union shall be left with no leadership capable of engaging the stakeholders in negotiations which are ongoing. 8. The applicant's intended appeal against the ruling and order of Honorable Lady Justice Helen Wasilwa will be rendered negatory if the orders sought herein are not granted, as the appellants have raised valid points of law and fact in their next memorandum of appeal, and the same has overwhelming chances of success. In the circumstances, that is 9, it is only fair and in the interest of justice that there be a stay of execution of the said orders of Honorable Lady Justice Helen Wasilwa pending the hearing and determination of the intended appeal. Otherwise, the object of their next application will be prejudiced, defeated, and the relief sought thereunder rendered negatory. 10. That this application has been made without unreasonable delay. The application was supported by the affidavit of one Dr. Frederick Ouma Oluga, who is the Secretary General of the Respondent Union, wherein they state that on the 7th of December 2016, the claimant's advocates duly advertised the orders obtained on the 1st December 2016 in the daily newspapers, wherein the applicants became aware of the orders issued on the 1st of December 2016. The orders of 1st December 2016 were issued to suspend a strike notice of 14 November 2016 and were advertised after the strike had commenced. The respondent contends that the orders of 1st December 2016 were obtained without disclosing material facts, to wit, A, the claimant has no employment contract with the respondent members, hence there is no employer-employee relationship. B, the strike notice of 14th November 2016 was issued to the head of public service and not the claimant, who are in any event the employers of the respondent. C, the claimant has no nexus with the respondents as relates to the collective bargaining agreement, and the claim file premised on attacking the collective bargaining agreement is misconceived and an unstarter. The applicants on 19th December 2016 came to court wherein they raised a preliminary objection based on the foregoing grounds, but the court declined to hear them and directed the ruling on whether the respondents were in contempt be delivered on 20th of December 2016. That the respondents were found in contempt and were ordered to appear before late Justice Monica Mbaro on 22nd December 2016 for sentencing. Honorable Justice Mbaro, however, they referred the matter back to Honorable Lady Justice Helen Wasilu as the trial court seized of the contempt proceedings. They contend that the court ought to have delved on the issue of jurisdiction first and foremost before delving into issues of whether a court order has been breached or not. The respondents allege that they have filed an appeal which is, in their view, meritorious and has high chances of success, and unless the orders sought are granted, the respondents state that they stand to be sentenced and will be denied their liberty, and if the intended appeal is allowed, the same shall be rendered negatory. This court declined to entertain the application before court, citing the principle that he who comes to equity must come with clean hands, and could not proceed to hear the pending application. The respondents further filed an application dated 24th of January 2017, which is now before court for determination. In the said application, they seek the following orders. 1. That the matter be certified urgent and be heard ex parte in the first instance. 2. That the Honorable Court be pleased to review its orders of 12th of January 2017, sentencing the 2nd to the 8th respondent applicants to a 1-month suspended sentence effective 26th January 2017. 3. Pending review of its orders of 12th January 2017, sentencing the 2nd to the 8th respondent applicants to a 1-month suspended sentence effective 26th January 2017. This Honorable Court order that the execution of the 1-month suspended sentence effective 26th January 2017 be suspended for a further period of 2 weeks. For pending review of its orders of 12th January 2017, sentencing the 2nd to the 8th respondent applicants to a 1-month suspended sentence effective 26th January 2017, this Honorable Court ordered that the 2nd to the 8th respondent applicant be released on favorable bail terms to ensure their attendance in court. 5. This Honorable Court be pleased to order the claimant, respondent, Council of Governors, and the interested party, second respondent, the Cabinet Secretary, Minister of Health, not to frustrate further negotiations on the subject matter and promptly call and attend all negotiation meetings. The court be at liberty to make such further orders as it deems fit and appropriate in the circumstances to meet the ends of justice. The application is premised on the following grounds. 1. That this Honorable Court has powers under Section 32 of the Contempt of Court Act 2016 to review its orders at any time. 2. That the 1st to the 8th respondents have in their best complied with the direction of this court for further engaging with the claimants, respondent, the Council of Governors, and the interested party, the second respondent, the Cabinet Secretary, Minister of Health, towards resolving the issues herein. 3. That the 1st to the 8th respondent applicants require more time to fully comply with the directions of this court or further engaging with the claimant, the Council of Governors, and the interested party, the Cabinet Secretary, Minister of Health, towards resolving the issues herein. 4. That this Honorable Court orders of 12th January 2017 sentence the 1st to the 2nd respondents to a 1-month suspended sentence effective 26th January 2017, place the 1st to the 8th respondent applicants at an obvious disadvantage during negotiations towards full compliance with the directions of this Honorable Court, of further engaging with the claimant, the Council of Governors, and the interested party, the Cabinet Secretary, Ministry of Health. 5. The claimant, the first respondent, Council of Governors, and the interested party, the Cabinet Secretary, Minister of Health, have used the advantage of the pending sentence effective 26 January 2017 to untwist and frustrate negotiations between the parties. 6. 1st to 8th respondent applicants verily believe that an extended negotiation period of a further 2 weeks strictly guided will ultimately result in an amicable solution to the current impasse. 7. The real and present impending custodial sentence of the 2nd to the 8th respondent applicants are further cause untold mental anguish and distress, further complicating good faith discussion. 8. That it's in the interest of the public and justice that a well-balanced bargaining approach be taken by both parties and directed by this court in order to avoid any possibility of a future dispute by an aggrieved party. The application is supported by the affidavit of the 5th respondent as the Secretary General of the 1st Respondent Union, wherein he reiterates the grounds on the face of the application and prays for the court to allow the application for review as drawn. The application is opposed by the claimant, the first respondent, the interested party, second respondent, and the claimants in course number 247 of 2016, who have filed their grounds of opposition to the respondent applicant's application of 28 January 2017. The first respondent claims that the application lacks merit, is calculated to delay due process, and is an abuse of the process of this honorable court. 2, that the application does not disclose a prima facie case with any likelihood of success. 3, that the application offends the mandatory criteria set for grant of orders of review. 4, that the balance of convenience militates against the grant of an order for review of the court orders dated 12 January 2017 in favor of the first to the 8th respondents herein. 5, that it is in the interest of justice and fairness that the respondent applicant's notice of motion dated 24th January 2017 be dismissed with cause. The interested party on their ground of opposition state as follows. 1, that the application does not meet the threshold of the review as set out in section 16 of the Employment and Labor Relations Act and the Employment and Labor Relations Court Procedure Rules of 2016. 2, that the applicants are barred from review of the court order of 12th January 2017 by virtue of section 16 of the Employment and Labor Relations Court Act and Rule 33 of the Employment and Labor Relations Court Procedure Rules 2016, as they have already preferred an appeal on the court orders of 12th January 2017 at the Court of Appeal, being appeal number 9 of 2017, filed on 17th of January 2017. 3, that the applicants have not demonstrated why they are still in blatant disobedience of the court order or how the review of the court orders will aid in purging the contempt. 4, that the application is an affront to the court and the judicial system as a whole, and he who seeks justice must come with clean hands. 5, that the Contempt of Court Act 2016 is inapplicable in this matter as it cannot apply retrospectively. 6, that the application is employed to delay justice and defeat the rule of law. That the court cannot be used to issue unwarranted and coerced orders against the respondent herein without firm and sound grounds and evidence. The applicants have not demonstrated how the respondents are frustrating the negotiations process, and the court is issuing such adverse orders will be an exercise in futility. 8, the application is otherwise misconceived, misplaced, and an abuse of the process of the Honorable Court, as the applicants are acting in bad faith, are engaged in forum shopping, and the same ought to be dismissed with cause to the respondents. The claimant in cause number 2479 of 2016 in their grounds of position state as follows. 1, that the application is incompetent, an abuse of the court process, frivolous, and the same ought to be not to be heard. 2, that the respondents have not purged the contempt and therefore they have no audience before the court. They cited civil cause number 242 of 2013, Africa Management Communication International Limited versus Joseph Madenge Mogo and others, whereby the learned Justice Mabeya, quoting from Chief Justice McKean of the United States, observed as follows, and I quote, "Since, however, the question seems to resolve itself into this, whether you shall bend to the law or the law shall bend to you, it is our duty to determine that the former shall be the case." End of quote. 3, that the application does not raise or introduce any reason as to why the court should exercise its discretion and review the orders of committal to civil jail, and they cited Johnson versus Grant, 1923, Supreme Court 289 of 2090, where Clyde Lord Justice noted as follows, and I quote, "The phrase contempt of court does not in the least describe the true nature of the class of offenses which we are here concerned. The offense consists of interference with the administration of law in impeding and perverting the course of justice. It is not the dignity of the court which is offended, a petty and misleading view of the issues involved. It is the fundamental supremacy of the law which is challenged. 4, that is the duty of every citizen to obey the court order, whether a party feels that the order is irregular or not, and the applicants are bound to obey the order they challenge to latter. These are the submissions that were filed before me. The respondents in submission said that they have taken steps to try and call off the strike and have annexed in their supporting affidavit minutes of the meeting between the ministry and the union, whose agenda was to try and comply with the orders of Justice Abodha on 1st of December 2013. They further said that this was in line with the court's orders to suspend sentence to allow parties to negotiate. They further submit that in negotiations, both parties must be involved. It cannot be a one-sided issue. It is their submission that during the suspended sentence, the claimant and the interested party were unwilling to engage in negotiations despite several meetings being set up for the purpose. The respondent called for an AGM with a view of getting the mandate to call off the strike as required by the Constitution, and the vote taken was against calling off the strike. The National Executive Council of the respondent union met, and still there was no agreement as to the calling of the strike. The respondents admit they have also presented a petition to the Parliamentary Committee for Health, who are having a meeting with the SRC on the issue. They submit that if the respondents go to jail, the union will be left without leadership for the period of 30 days, which will further delay the resolution of the matter. They pray for the court to give timelines in order to structure negotiations. The respondent and the interested parties submit that the application does not meet the threshold of the review set out in the Employment and Labor Relations Court Acts, Section 16, which states as follows, I quote, "The court shall have powers to review its judgments, award, orders, or decrees in accordance with the rules," end of quote. Rule 33 of the Employment and Labor Relations Court Procedure Rule provides as follows, and I quote, "A person who is aggrieved by a decree or an order from which an appeal is allowed, but from which no appeal is preferred, or from which no appeal is allowed, may within reasonable time apply for review of the judgment of the ruling. A, if there is discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of that person or could not be produced by that person at the time when the decree was passed or the order made. B, on account of some mistake or error apparent on the face of the record. C, if the judgment or ruling requires a clarification. Or D, for any sufficient reason. That the applicants have already filed an appeal against the ruling of this court, and as such, review orders cannot apply. They rely on the case of William Karani and 47 others versus Michael Wamalwa Kijana and 2 others, Nakuru Court of Appeal 43 and 153 of 1986, explaining the nature of review stated as follows. Section 80 and Order 14, now Order 45 of the Civil Procedure Rules 2010 is a means of airing gross or obvious errors when an appeal is allowed by the Act from a decree or order but no appeal has been preferred, and secondly in cases where no appeal is allowed at all. From the nature of Section 8 and Order 44, both procedures cannot be adopted at once. Hence, supposing that an appeal is allowed by the Act but has not been preferred, review may be taken if appropriate. Once an appeal is taken, review is ousted and the matter to be remedied by review must merge in the appeal. The second respondent also relies on the case of Board of Governors, Moi High School, Kabarak and another versus Malcolm Bell, Supreme Court, petition number 6 and 7 of 2013, and reported, where it was succinctly alluded that a court obtains jurisdiction to hear and determine matters from either the Constitution or legislation or both. Therefore, a court cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. It must operate within the constitutional limits. Moreover, the inherent power of the court is meant to prevent its powers from being misused in such a way as to diminish its capability to arrive at a just decision of the dispute. Once an appeal has been preferred and the door for seeking the remedy has been preferred, the door for seeking the remedy of review is closed. The second respondent further submits that the Court of Contempt Act number 46 of 2016 cannot apply, as the commencement date for the same is 13th of January 2017, whereas the applicant was sentenced on 12th of January 2017. They state that the law looks forward and not backwards, as was stated in the case of Municipality of Mombasa versus Nyali Limited, 1963, EA 371. The second respondent also contends that they cannot be compelled to attend any negotiation meetings until it be beyond the court's mandate. They rely on the case of Wamwere versus Attorney General 2004, 1 Kenya Law Reports, where the applicant sought an order for mandamus. The court held that the application cannot succeed unless it can be shown that there was wrongdoing on the part of the respondent. The claimant, interested party, and the claimant in 2479 of 2016 pray for the application for review to be dismissed with cause. I've considered the averments and submissions of all the parties herein. I set down the issues that this court is determining as follows. Number 1, whether this court has jurisdiction to hear this application for review, the applicants having already preferred an appeal at the Court of Appeal. Number 2, if the answer to number 1 above is yes, whether the Contempt of Court Act 2016 apply to this application. Number 3, if the answer to 2 above is no, which law then applies? 4, whether the applicants have met the threshold for the grant of orders sought. And number 5, which orders to grant in the circumstances. On the first issue, this court draws its jurisdiction from Article 162(2) of the Kenya Constitution 2010, and Section 12 of the ELRC Act, which states that the court has jurisdiction to handle any matter relating to employment and labor relations. Under Section 16 of the ELRC Act, this court also has jurisdiction to review its own judgments, awards, orders, and decrees in accordance with the rules. The rules referred to herein are the Employment and Labor Relations Court Procedure Rules 2016, where Rule 33 of this rule states as follows. A person who is aggrieved by a decree or an order from which an appeal is allowed but for which no appeal is preferred, or from which no appeal is allowed, may within reasonable time apply for a review of the judgment of the ruling. A. If there is discovery of new and important matter or evidence which after the exercise of due diligence was not within the knowledge of that person or could not be produced by that person at that time when the decree was passed or the order made. B. On account of some mistake or error apparent on the face of the record. C. If the judgment or ruling requires clarification. Or D. For any other sufficient reason. These rules are couched in similar terms as Order 45 Rule 1 of the Civil Procedure Rules, which state as follows. Any person considering himself aggrieved A. by a decree or an order from which an appeal is allowed, but from which no appeal has been preferred, or B. by a decree or an order from which no appeal is hereby allowed, and who, from the discovery of new and important matter or evidence, which after the exercise of due diligence was not within their knowledge or could not be produced by him at the time when the decree was passed or the order made, or on account of some mistake or error apparent in the face of the record, or for any other sufficient reason, desires to obtain a review of the decree or order, may apply for a review of the judgment to the court which passed the decree or made the order without unreasonable delay. A party who is not appealing from a decree or order may apply for a review of judgment, notwithstanding the pendency of appeal by some other party, except where the grounds of such appeal is common to the applicant and the appellant, and when being the respondent, he can present to the appellate court the case on which he applies for the review. From these rules, it's apparent that an application for review may be preferred if an appeal is not being considered, or where an appeal is not allowed. In the case of the applicants herein, however, this court has already been notified that they have filed an appeal at the Court of Appeal, and at the same time they have filed for review, which in my view is tantamount to forum shopping. This was the holding in the Court of Appeal case of William Karani and 47 others Supra, where the court found that once an appeal has been taken, the review cannot proceed, and the issue ought to be remedied by the review must be merged in the appeal. On the second issue, the court has already determined that it has inherent powers to review its own judgment and orders as provided for under the LRC Act 2016 and even the Civil Procedure Act. This inherent power of review was tested and applied in the case of High Court Civil Case number 45 of 2008, Machakos, where the Honorable Justice Hatari Waweru considered an application for review in a contempt matter and dismissed it as there were no valid reason to warrant the review. This same power of review is not ousted by the new Contempt of Court Act 2016. However, the Contempt of Court Act, having come in force on 13th of January 2017, will not apply in this case, as the contemptuous were sentenced by this court on 12th of January 2017, and the new act cannot act retrospectively. Under Section 9(2) of Cap 2, Interpretation and General Statutes Act, if it is enacted in the Act or in any other written law that the Act or any provision of thereof shall come or be deemed to have come into operation on some other day, the Act, or as the case may be, that provision shall come and be deemed to have come into operation accordingly. In this case, therefore, the Contempt of Act 2016, it came in force as stated therein on 13th of January 2017, and so cannot apply retrospectively. This also answers my issue number 3 above. Given that I've answered issue number 1 above in the negative, it will be superfluous to go and answer issue number 4 above. Nonetheless, I will answer the question by stating that considering the parameter to be applied in declining whether to allow a review or not, the applicants must demonstrate to court that there is discovery of new and important matter which was not in their knowledge before, or that there is an error apparent on the face of the record, or that the ruling requires some clarification or interpretation for sufficient cause. The applicants have demonstrated to court they have not demonstrated to court any new and compelling issue or pointed out any mistake or error apparent on the record, nor any sufficient cause that will warrant review of these court orders. Indeed, they have submitted that they are engaging in negotiations ordered by court on 1st December 2016, but they have not explained why they chose to obey part of the order and fail as officials of Kenya Medical Practitioner and Dentist Union to call off the strike as ordered by the same court. Indeed, they have also found their inability to call off the strike, which they themselves called on. It is this court's finding that there is no sufficient reason why the court should review its order, and therefore this court declines to review its orders sentencing the applicants to 1 month jail term, and the orders of this court will now crystallize. Those are the orders of this court. So I finish. I think I'm functioning as official. Negotiations may proceed. The Court of Appeal may proceed and make any other determinations on the issue. But you can now start serving your sentences. Those are the orders of the court.
They can start serving the
The Commercial Division, where Judge Helen Wasilwa has just delivered a ruling on an application by the Doctors Union asking for a review of a ruling he had issued earlier in the year, asking that the 7 officials of the Kenya Medical Practitioners and Dentists Union be sentenced and serve 1 month court sentence for contempt of court. The doctors had moved to court again asking that she reviews this, but she has said with everything going on, the doctors have failed to show as reason as to why they should not have called off the strike. One of the reasons as to why the judge had initially suspended this sentence was to give the doctors time to go and enter into negotiations with the aim of calling off the strike. This has not happened despite numerous attempts. There have been meetings between the doctors, the government, and lately, just as late as last week, the Kenya KOTU and the Kenya National Commission on Human Rights were also roped in to try and just get these doctors and the government on a negotiating table with the aim of getting a deal that will bring to an end this strike that now enters its 67th day. For 10 weeks, the doctors have not been going to hospital. They have been on strike demanding implementation of a 2013 CBA, but the doctors now, according to what the judge has says, as it stands right now, the orders and that sentence that was handed out to the doctors in January begins to crystallize. He says, she says that the doctors now prepare, the doctors union officials prepare to start serving that 1 month sentence. At the same time, while saying that that sentence has to carry on as had been ordered earlier on, she says the talks that have been going on for the last 1 month, for 1 week, between KOTU, KMPDU, KNHCR should continue. The trade union, the Kenya National Commission on Human Rights had actually asked the court here today to give them a little bit more time, just about 1 week, to ensure that they would bring to a table a return to work formula, a negotiated return to work formula that they would then register with the court and sign before this court. It is one of the reasons as to why the the doctors union had been asking that this sentence does not start, because they said the negotiations are at an advanced stage. the judge agreed, but at the same time wanted them to give more reasons as to why, more proof as to what has already been achieved. The Kenyan Human Rights Commission and the Doctors Union had said they have made a lot of progress in the last 1 week. The judge wanted proof of that. It was not availed to her. But she says, given the fact that both the Doctors Union and the Human Rights Commission have indeed committed to coming up with a return to work formula within 1 week, that progress should not be halted. But at the same time, the Doctors Union leaders will not be part of that process moving forward. The doctors had asked for just 1 week, so we expect that if these talks continue as ordered by the judge, by next week, Thursday, the doctors and the National Human Commission on Human Rights will be coming back to court with that comprehensive return to work formula. We do know that yesterday, court, which had been part of these negotiations and mediation talks, had indicated that the talks had collapsed. But the Kenya National Commission on Human Rights indeed submitting to the court here today that they were holding meetings at late as 1 a.m. today, trying to get a solution to this. Perhaps one of the reasons as to why the judge granted them that leeway. But as for the doctors' case, we do now know that they will begin to serve the contempt of court sentence that had been handed over to them. This strike, like I mentioned earlier, has been ongoing for a record 10 weeks, starting on the 5th of December last year, when the doctors officially downed their tools after a protracted engagement between them and government over the CBA of 2013. That CBA that has been, of course, dismissed and trashed by the court. This particular court has declared that that document is not legal, it's not legitimate, and therefore cannot form any basis of negotiations between the doctors and the government. The doctors, on the other hand, have maintained time and again that any negotiations they will undertake with the government has to be on the basis of this CBA of 2013. So that is exactly what is happening here at the Milimani Commercial Law Courts. We expect that the doctors who are in court just finished their session in a few minutes will be coming down from here. It is also imperative to note that Kotu has not been represented in court today. Yesterday, the Secretary General Francis Atwoli mentioning that he had been unable to bring sanity to these talks to resolve the crisis earlier on before the court ordered that his organization and the Kenya National Commission on Human Rights be part of this talks. He had said that if he is involved in this, it will not take him more than 2 days to find a solution. But yesterday, by his own admission, he said these talks were not moving in the direction that he had hoped they would move. He had asked the doctors to take the offer that had been issued by the government towards the close of 2016 by the president himself, offering the doctors 40% pay hike, and to take this offer, run with it, and come back for to demand more later on. But the doctors, of course, as has been the case, did not heed to that, maintaining that nothing short of the CBA of 2013 would have them go back to work. So those are some of the things that have been happening here at this law courts. We also do know that as of yesterday, according to the Kotu Secretary General, in his admission that he had not been able to do what was needed to end this strike, he had said that infighting between top officials at the Ministry of Health, that is the Cabinet Secretary, Dr. Cleopa Mailu, and his Permanent Secretary, P.S. Muraguri, had been one of the key factors that had been frustrating talks, frustrating mediation efforts. And it is this thought of frustration between infighting and frustration from Ministry of Health officials has been a recurrent theme throughout these negotiations. We've had even the doctors themselves appearing before the Senate Committee of Health just last week, telling the chairman of that committee Dr. Mashage that although they were willing to soften their stand, it has not been easy for them to actually get their thoughts across, largely because of what they say has been frustrations and intimidations and threats coming through from top government officials, a fact that has again been reiterated by the Cotu Secretary General. So it will be interesting to see just where this goes. This matter, of course, has attracted a lot of attention, especially from members of the Doctors Union, who at every court appearance, they have been coming here in their holds. Today is no different, right? Just outside these courtrooms today, they were not allowed access into the court grounds, but if you can hear from the noise, quite a number of them actually gathered outside protesting, chanting at the result of today's court hearing. So it will be very interesting to watch how this plays out, because what normally happens is that after every court hearings, the officials would lead them from this place to their traditional meeting place at Kenya Railways grounds. But today, with what the court has just decided, we don't know what direction they will be moving from here. Whether the court officials from here will also come straight from here and head to their respective facilities is something that we will have to wait and find out. So a lot of exciting scenes here at Milimani Law Courts. This case, like we mentioned earlier, has been ongoing for quite some time now, but the cracks of it actually coming down in January when these union leaders were sentenced by Justice Helen Wasilwa to serve a 1-month suspended jail term for contempt of court. They had been asked by the court through the Council of Governors, who had moved to court, asking them not to undertake this industrial action. But by the 5th of December, when the industrial action started and they came back to court about a week later, they said they couldn't stop the strike because it had already started. And consequently to that, they were found to have been in contempt of court and sentenced to that 1-month jail term. Although they had also been given 2 weeks at that time of the suspension, a suspended sentence, to try and find a solution to this. That 2 weeks came and went. They came back to court again. They were granted another week. It came and went. They came back to court again and they were granted now this final week of mediation. What you can hear, we can actually see right now, I don't know whether you can see, is a police car, I think, with the officials inside just leaving the courtroom right now. I don't know whether my cameraman can just pan with me for a little bit. We can see the van just moving outside with the officials. You can hear the shouts and screams greeting the officials as they make their way to start serving that 1-month sentence. So it has finally, like they say, the long arduous journey ends with the jailing of the leaders, leaving the courtroom right now, going to, I don't know which jail facilities they will be going to, but earlier on, we remember Justice Wasilwa had said the ladies might be sent to Langata Women Prison, the gentlemen to any other facilities within the capital city. I think details of that will be coming much clearer once they get to where they're supposed to be going. So that brings to an end dramatic events here today. Earlier on in the dock where the doctors were, the doctors union leaders were in the dock with their sentence being read out. They were quite a subdued lot, opposed to what we've seen in the past. I think perhaps the reality of what was going to happen hitting them hard, but they've left the courtroom heading to their various destinations. We'll be bringing you more details as we know exactly where they will be taken to. Back to you, studio.
Brenda Wanga there outside the Milimani Law Courts, bringing up to speed with what happened this morning. Indeed, a dramatic morning. We've been bringing it all to you live right here on NTV today. You've been watching the ruling of the doctor strike at the Milimani Law Courts. Breaking news that the KMPDU officials are now set to serve a 1-month jail term. Earlier we saw the images of the officials in the court being handcuffed, although they did have smiles on their faces. And then outside the court, what you're seeing are supporters and doctors demonstrating outside that courtroom. I do believe that the officials have been whizzed off now in those police vehicles. And with me now in studio is our senior reporter and lawyer, Ken Mijungu. Ken, you've been following this story for a while now. Such dramatic developments. What do we make of this? Was it somewhat expected?
It was expected, I would say so. And let's begin from when the officials were being handcuffed and they were smiling. I mean, jail time should traumatize you. But the fact that the officials were smiling, it means that was expected. That was the most possible outcome. Look at some of the documents that the judge, for example, said she was not furnished with. So she couldn't make any other decision apart from the one she's made. That means they did that probably deliberately, because now this makes them look like celebrities in front of the doctors. Remember, they said during their AGM, the membership declined to authorize them to call off the strike. So for them going through with this, and remember they've said several times they're ready to go to jail.
Right.
It makes them look as celebrities. That's why they're all smiles.
So you think that really this is a move just to please the other doctors? They're doing it for the other doctors rather than for the nation at large?
No, not really. The fact that they have done this solidifies their standing among their peers in the doctors, in that the doctors can now trust them. I'll take you to several industrial actions, including the teacher strikes. Most of the time, the officials, the union officials, have been accused of going to bed with the government to frustrate strikes. They go, they get paid some money, and then they call off the strikes. So for doctors, having gone with this to the final end, that was the most possible conclusion of this case. There's been a back and forth since January. It shows their peers that indeed they're the best leadership for them. So it has just solidified their position and standing in the society, and especially the society that is of the doctors.
All right, well, what we're seeing is still, doctors and peers demonstrating outside the law courts. What happens now with regard to the strike? What's the way forward?
The strike is still on. The only people legally mandated with the MOUs and the constitution of the KMPDU are the officials to call off the strike. One of the arguments that they brought before the judge was that if you take us to jail for 30 days, in effect what you're doing is frustrating an agreement that can forestall this stalemate. So you take us for 30 days, trust me, for the next 30 days the strike is on, because the only people who can call off the strike are the union, and the union officials are in jail. It means for 30 days they're still on strike.
So really, this is not a solution. We're not going to see doctors back in hospitals and patients being attended to by doctors.
The only way they will go back to the hospital is through calling off the strike. The only person who can call off the strike legally is the Secretary General. Is Omo Oluga.
So
he's in
He
jail. Cannot do that from jail. And they have to hold the meeting that they'll mutually agree. Remember last week we said, Smriti, that for the doctors to agree, everyone has to come on board. Everyone has to sit on the table. And remember, the doctors have all the time said, you know what? They're frustrating us from the ministry and so long as we are not sitting and talking, and it has to be both ways, we can't call off the strike.
So what then does this ruling really achieve?
One thing is, remember, Judge Wasilo was basically dealing with a case of contempt. I wanted to mention they were prepared for this also before I go to the contempt case. They're prepared for this in such a way that they will have transitional officials to go ahead with this, because the membership still needs to be addressed, they need to be talked to. So there must be some officials, interim officials, while these guys serve the jail term, that will be handling in case they need to sit and talk. Right. They have. But going back to Judge Wasilwa.
Right, Ken, for just a moment, we need to cross back to Brenda Wanga, who's there outside the court, because remember earlier this morning, the KNCHR, that is the Kenya National Commission on Human Rights, was present. They are seeking, or were seeking, for an extension to finalize these talks. Brenda has the lawyer lined up and she's about to speak to him. Brenda.
Yes, Mriti, I'm joined by Victor Kamau, a lawyer with the Kenya National Commission on Human Rights, one of the parties that was involved in this mediation and is still involved in the mediation talks between the Kenya Medical Practitioner and Dentist Union and the government to the view of getting a way out of the ongoing strike. Today, you are in court and you've seen what has transpired. What is your reaction to the judge's order that the Doctors Union actually go ahead and serve that 1 month jail sentence?
I can't hear a thing.
Sorry. We'll again ask Victor Kamau, what is your take on what has transpired here today?
Yes. Well, we came hoping that we'll get a little more time. We had made very good progress in the negotiation, in the mediation rather, and we were really hoping that we would have had even a week to try and complete mediation. And I hope that despite this setback, we shall still be able to engage the parties and remain involved in the process. Yeah.
Initially, you had asked the judge to give you 1 week. You said you had made some significant steps. You had agreed on quite a number of things. You were almost ready with the return to work formula. Perhaps you could just tell us what are these issues that are still pending that you need this 1 week to complete?
Well, we have been actually working very tirelessly as a commission because there are very many issues that were outstanding. And I think there is no very simplistic solution to this problem. We understand, of course, the effect that it is having, and that is why we have actually been completely embroiled in the discussions. I think we shall have to explore our options now and probably talk to you a little later with more information.
What is the first impact of the judge's decision to have the officials serve their jail term in relation to the fact that she also gave you 1 week to continue the negotiations, and now these people have been taken off the table?
Excuse me?
I think we're having a little bit of a challenge there. So basically what he's saying is the sentence, of course, will have an effect on the talks, but they're optimistic that they will find a way out of this set of, a new hand that they have been played. They have 1 week to mediate and get a solution, but at the same time, a crucial part of the people they're supposed to be talking with are now locked away. So we will still be getting more information and keeping it here for more updates as we get them. Back to you, Smriti.
All right, Brenda, thanks very much indeed. More from you as the morning progresses. Ken, the representative there from the Kenya National Commission on Human Rights didn't quite say much.
Yeah, basically it's because he has nothing to say. Remember when he went to court this morning, what he said was that they have actually drafted down a return to work formula, which they were hoping to append their signatures, and that's what's still pending. However, the judge did not make any reference to that. I will give two reasons why. Last week, when she was giving the additional 5 days for mediation, she mandated Court Secretary General Francis Atwoli to spearhead this. And there were several agencies, about 11 of them, Ministry of Labor, the Kenya National Human Rights Commission, we had Ministry of Finance, we had the Doctors Union and the rest. And Francis Atwoli was supposed to spearhead this. And below Francis, she specifically mentioned the Kenya National Human Rights Commission. And then Atwoli yesterday said that he has been unable to forestall this. And then he comes to court and say, we have even drafted the return to work formula. So it was a tough balancing act between believing what they said, and to me, it's been a circus. all through the last 1 month and plus. The judge goes to court, has to extend, and obviously she has to give dialogue a chance, and then she has to come to court, postpone. The image, remember last week she also said, the image of the court is at stake, which is very important, because people start looking at this court as a court that is toothless, can't take actions, can't possibly take any form of action, it backtracks all the time in making decisions. So she needed to be very decisive with this today. That's why I look at her, even the body language. She got to court, she never smiled to the end. She waited for them to submit and made her ruling and said it crystallizes, done.
So do you think this ruling was made perhaps just out of frustration, just, make a decision, let's do one thing or another?
First thing is rule of law. She had to remember this is just a contempt of court proceeding. She was basically, this case was before some other high court. She was supposed to determine if at all the Council of Governors had a point. They were just trying to prevent this industrial action by I think it was about 14th of November last year. But it happened. So they went to court and obtained orders temporarily barring the unions from calling off the strike. 5 days after they went to court and obtained the orders, the union called the strike. That was pure contempt of court. So they had to go to court again to say, you know what, we got orders, but these guys disobeyed. So this was purely on the contempt of court, and she's ruled. It means the case in court that the Council of Governors table then still continues. It doesn't stop at all. So moving on from today, they will go ahead with that other case now to look at all those things, including dispute about the CBA that has been in the media for a long time. So it now goes on because the contempt of court proceeding has crystallized.
Right, okay. Well, let's just look forward now. With these KMPDU officials currently on their way to prison, which prisons are we expected them at?
It was mentioned the other time, I think 3 weeks ago, she said the ladies will go to Langata and the gentlemen will go to Kamiti. So probably that's why they will go. So they'll first pass by industrial area briefly, their rooms will be created the other side, and then they'll be deposited in that.
All right, so that's for a period of 30 days.
30 days,
While they are in prison, can they take any action? Can they do anything related to the strike?
It will be impossible. One of the things when they were asking for a review to this case, they asked and submitted, they said, we need these days, because if you jail us, one will not be able to talk to our membership.
Right.
The other...
Ken, I beg your pardon, we need to cross over live to Andrew Ochieng. He, I believe, is also outside the Milimani law courts. He spent most of the morning amongst those demonstrators and the colleagues and peers. Andrew, over to you.
Where members of the doctors' union, that is the Kenya Medical Practitioners Union, just have been protesting all the way from the Milimani law courts, demonstrating against the sentence that has been handed to some of their officials who have just been sentenced for the 1 month period. So here we are at the Ministry of Health. They have been chanting, they've been saying they do not want Mailu anymore they don't want Mailu out of the ministry just after the sentence has been given by the High Court Judge Helen Wasilwa. And I was just trying to get one of the officials here to tell us what the plan is and what the mood is from now going forward. They've said that they are going to demonstrate all the way to the Central Business District. Their officials, we understand, have been taken to the industrial area, remand area, where they will be serving the 1 month sentence as we wait for what further word for what is going to happen. But right now, I will just try to get one of the officials to explain really how they will carry the mood going forward and what the negotiations now will be going forward. Excuse me, gentlemen.
Yes, my name is Dr. Mark Ndogo Maroge. I'm an official, Upper Eastern Branch Secretary. Today is an unfortunate day that industrial disputes are settled by way of imprisonment. However, doctors believe they're on the right side of history today, and we can only hope that someone will intervene and settle the way it's supposed to be, not by jailing our leaders. It's very unfortunate.
What is the progress now? What are you guys doing? Where are you protesting to, and what is the way forward now?
No, so far there is no official direction on how we'll go. We just meet as doctors, deliberate on today's happenings, and then we'll see the way forward from there.
How has this affected the negotiations going forward? What do you think is going to happen probably tomorrow? Because the Kenya National Commission on Human Rights has said that the negotiations have been successful. How is this going to affect your negotiation? How is it going to do that?
definitely it will affect the negotiations because we have no one to negotiate with. As when you jail our leaders, then who do you negotiate with? So it is an unprecedented move. We hoped that the justice system would prevail today and give talks and negotiations a chance. But going forward, we don't see how that will proceed when our leaders are behind bars.
Have you filed an appeal already?
Yes, appeal is in the courts, in the high courts, and we wait further directions from the courts.
Okay, thank you very much, Dr. Ndungu. Your name is sir?
Yes, my name is Dr. B. Ismail, Branch Secretary Northrift. Today, I think, as you said during when the strike was commencing, that is a sad events is rolling down in Kenya. As we see doctors going to jail for championing rights for Kenyans. And I think this calls for the leadership of the country to rethink and our social fabric to really think, do we really need to go this far when people are championing for the rotten public health sector and there is need for the country to sit down and see where our humanity is. Because what the doctors are saying is the health system, public health system is rotten, we need to fix it. Instead of the issues being heard, they are being jailed. I think it's a sad day.
So how are you going to negotiate now going forward? Was there a plan? Did the officials ever have a plan of carrying the negotiations forward, given that the sentence has been suspended for quite a while now?
I think it's important to note that the union structures are the negotiating team is led by the Secretary General, and you can see he's in behind bars, so there's nothing to negotiate, nobody to negotiate. Yeah.
Okay, thank you very much, Daktari. So there you have it, Smriti, there in studio, that the ampers right now is even worse than it was before, now that there is no one to negotiate with the doctors. But we are going to follow them wherever they are going, and we are going to keep our viewers updated on how they are going to probably form another team to negotiate, given that now the Secretary General and other senior officials of the union have been jailed at the Industrial Area Court. Back to you there in studio.
Andrew Cheng, thanks very much indeed. We will be on the ground with you as and when the morning developments progress. So Ken, before we crossed over to Andrew, we were talking about the fact that these union officials are now going to be in prison and cannot really take any action from there. But according to some of the doctors that Andrew just spoke to, they don't have a way forward. And one of the doctors said that this in fact is an unprecedented move, and they hoped that justice would give talks a chance.
You see, to me, from the top of my mind, that's what they have to say, because one, they didn't expect they would be jailed. Two, they expected also they'll be jailed. That's a possibility. There are only two possible outcomes. You can't say there was a third. Jail or no jail. So if we were to go to jail, what will happen to the talks? They will collapse. If we don't go to jail, what will happen? We'll continue the dialogue. But remember, this has been a circus, even to the court, to the extent that the image of the court was at stake. So the court sort of, you asked me a question earlier, did they just roll this to get over and done with? I said first is the rule of law. And then remember, a contempt of court hearing and sentencing is a discretion of the judge who is sitting there, which means she could have given them an alternative to a bail so that they can continue with their negotiations. But she was very clear about it. 30 days, jail term. Unless they go to appeal such that they get bailed, which is possible because every offense nowadays in this country is bailable, so that they continue with the negotiations. But that will happen later because they have a window period of about 14 days to make that application.
Okay, and Ken, you're saying that, you know, or referring to this as a circus. Some may think that perhaps is a tricky word to use because you associate a circus with, you know, tricks and games and all of that, yet we are talking about serious national issues, healthcare. I know. Look at what has been happening straight after a court session every single day where dialogue has been given a chance. The KMPDU officials get outside the building, and what is the first thing they do? They make a statement to the effect that, you know what, regardless of what they say, if they don't implement this CBA as it is, what will be on the streets? So straight their mind was made, even when they were given a chance to go and talk. And this is plain, because we've been covering this story. Oluga will get out of court and say straight and say,
unless this is implemented, we will be on the street. So he was not giving a chance to anything. And look at what the government has said. The doctors are not ready to negotiate. Look at what Atwoli said. He tried and he believed and he called those young men, including Atwoli, who is a son, who is a doctor, that those young men, there was something else apart from just implementing this CBA, right? So every time they will go to court and get out of court, they will make the same statement that took them to court. So you wonder, were they really committed to negotiations, or they were not committed, simply going to court? And each time, the reason why, it's not me who's referred. Look at all the analysis. Yeah. They refer to it as a circus. They go to court, they're extended, they're following the same thing throughout.
Although this cannot solely be blamed on the doctors, because this back and forth, of course, requires a second party, and that is the government, that is the ministry.
Yes.
So it really is a two-way thing.
Yeah, and the circus is from both sides.
Right.
Really, yes.
Okay, and what are the possible ways forward? Because as Andrew spoke to some of the doctors, they said that they will now await further direction from the court. What does that mean? Are they helpless, and will they still keep away from the hospitals?
As of now, the only person who is capable of continuing with any form of negotiation, any form of negotiation must be led by the Secretary General, who is now in jail. Yeah. It means that's impossible. There is no second plan to this, that you'll say that, oh, there are some officials who are still outside, for example, from the regions, who can continue the negotiations. No, Omar Oluga has to be on the table to negotiate with. If it's a government or any other agency, he has to be there. He's in jail. The only possible way here is to grant bail, is to get an appeal, and a bail is granted, and they get out and continue with the negotiations. Otherwise, there is no second way to this. I mean, that's what the Constitution, binding the doctors to the official state.
Right, so what we've got right now is the officials of the KMPDU in jail or on their way to jail, doctors still out of hospitals, and patients in hospitals still very, very helpless, because this ruling has not really created a solution. Doctors are not going back to work, despite the fact that the court has ruled that they ought to be put in jail. All right, let's just take you back to Brenda Wanga now. She is still around the Milimani area. Brenda, what do you have for us?